Saskatchewan's Court of Appeal says a legal challenge to that province's rules on preferred pronouns in schools can move ahead.
The court was very clear in reinforcing the important role of courts in general in reviewing government action to make sure that it's constitutional.
In 2023, Saskatchewan passed a law stating students under 16 can't use preferred names or pronouns at school without parental consent. That law passed using the notwithstanding clause, which allows governments to enact legislation known to violate the Charter of Rights and Freedoms. Specifically, Saskatchewan acknowledged that its pronoun law ignores charter rights to free expression, liberty, and equality, but passed it anyway. Regina-based queer community group UR Pride took the law to court, challenging that it also violates Section 12, freedom from cruel and unusual treatment or punishment.
If we are successful in establishing that the law violates Section 12, the court will be able to strike down the legislation. So
Saskatchewan's position is it doesn't matter if the law doesn't name Section 12 specifically. The province argues once the notwithstanding clause is invoked, legislation is immune to judicial review. The appeals court now disagrees and says a lower court can rule on whether the law is constitutional at all. City News contacted the office of Saskatchewan Education Minister Everett Hindley, but didn't receive a statement in time for broadcast.
What's really at stake here is our fundamental rights and freedoms, the sanctity of our notwithstanding clause in the Charter of Rights and Freedoms, but also who we are as a country. Are we a country that accepts different kinds of families, or do we treat difference as something to be scared of and threatened by?
Saskatchewan can appeal the decision to the Supreme Court of Canada. If not, the case returns to a lower court. In Ottawa, Shally Lee, City News.